Before the 20th century, police questioning was simple and brutal. Confessions were often extracted through force, intimidation, or outright violence. Courts eventually realized this was incompatible with justice, so they banned physical coercion. But when they closed one door, another opened. If police couldn't force a confession, they needed new tools: psychological pressure, strategic manipulation, and eventually, deception. Here's where the world diverged. The US embraced deception through the Reed technique, which encourages officers to present false evidence, invent witnesses, imply guilt is already proven. Officers can say, "We found your DNA. Your friend already confessed. We have you on video," even if none of it is true. The UK took a very different path. Under the Police and Criminal Evidence Act, PACE, officers cannot fabricate evidence, falsely claim a co-suspect confessed, bluff about DNA, CCTV, fingerprints, or witness statements, or imply guaranteed leniency. Any confession obtained through trickery, inducement, or unfair pressure can be thrown out. What UK officers can do is withhold information, ask challenging or misleading questions, or test a suspect's account. But they cannot invent evidence to provoke a confession. Jurisdictions like Australia, Canada, Hong Kong, and Singapore sit somewhere in the middle. Limited deception may be allowed, but confessions must remain voluntary, and courts can exclude statements obtained through unfair tactics. So the global pattern looks like this. In the US, broad deception is allowed. In the UK, deception about evidence is prohibited. In Australia, Canada, Hong Kong, or Singapore, limited deception is allowed, but voluntariness is key. And the line between acceptable questioning and oppression, the point where a suspect's free will is overborne, is thin enough to break. This isn't just a legal technicality. It affects anyone who's ever been questioned, detained, or even casually spoken to by police. Depending on where you live, you can be told evidence exists when it doesn't, your friend betrayed you when they didn't, you're facing harsher charges than you really are, or confessing will help you even when it won't. People confess to crimes they didn't commit, not because they're guilty, but because they're scared, confused, exhausted, or manipulated into believing the situation is hopeless. False confessions appear in wrongful conviction cases across the world, and in many of them, deception played a central role. One of the most famous examples is the Central Park 5 case in the US. 5 boys, aged just 14 to 16, were interrogated for hours without lawyers and in some cases without their parents present. They were questioned through the night, exhausted, scared, and told again and again that the others had already confessed. None of it was true. There was no confession from their friends. There was no forensic evidence linking them to the crime. But after hours of pressure, each boy broke. They confessed on tape, and those confessions became the centerpiece of the prosecution's case. Years later, DNA evidence proved they were innocent. Their convictions were overturned, and the case became a global symbol of how deception, especially against young or vulnerable suspects, can produce catastrophic injustice. In the R versus Oikel case in Canada, police told the suspect he failed a polygraph test. Even though polygraphs are notoriously unreliable, they implied he'd face harsher consequences if he didn't confess. The Supreme Court upheld the confession. They said the deception didn't cross the line into oppression. Critics argued the opposite, that the line had been erased entirely. In Australia, the High Court took a stricter approach in a case called R versus Swaffield. Police knew the suspect had already exercised his right to silence. So they sent in an undercover officer posing as a friend, someone Swaffield trusted, who then actively drew out incriminating admissions. The court ruled the confession inadmissible, not simply because there was deception, but because the deception was used to bypass his right to silence. The police had done indirectly what they were not allowed to do directly, and that made the confession unfair. This case shows the tension perfectly. Courts don't ban deception. They ban deception that goes too far. But what counts as too far is different in every country and every courtroom. Police argue that deception is necessary. Criminals lie. Evidence is hidden. People don't confess unless they believe the situation is hopeless. And deception, they say, is just another investigative tool. They argue that banning deception would cripple investigations, especially in cases involving organized crime, gangs, or serious violence. And to be fair, there are cases where deception has revealed the truth, where a suspect confessed to a crime they genuinely committed, and justice was served. Critics argue the opposite. They say deception doesn't uncover truth, it manufactures it. It creates false confessions. It punishes the vulnerable. It rewards manipulation over evidence. And it undermines public trust in the justice system. They argue that if the police can lie, the playing field is never level, because the suspect doesn't know the rules, and the police don't have to tell them. This isn't just a legal doctrine. It affects anyone who might one day be questioned, even as a witness, even as a bystander, even when you've done nothing wrong. It affects young people who are more likely to trust authority. It affects migrants who may not understand their rights. It affects the vulnerable, the scared, the inexperienced. And it raises a question that every society has to answer. How far should the state be allowed to go in the pursuit of truth? So here's the question I'll leave you with. Should the police be allowed to lie to suspects, or does that undermine the very idea of justice? If you enjoyed this video, feel free to follow the channel for more.